We'll let the record reflect. Oh, there he is. Okay. Mr. Mata, are you ready to proceed this morning?
Yes, ma'am.
Okay. And is the commission ready?
Yes, Madam Chair. This is Douglas Lang, appearing for the commission. We're ready to proceed.
Okay, thank you. That completes the docket call. We're going to call the Mata case first, followed by Duke, and then Bruno. So we'll excuse all the non-participants into the waiting room, and only the parties and counsel for the Mata case will remain. This will take probably at least 40 minutes. So if you want to get a cup of coffee and join us back in 30 or 40 minutes, it'll probably be that long before we get back to you.
Okay, thank you.
Thank you.
It would be best if I had a speaker.
It looks like we only have the participants for the Mata argument present in the courtroom at this time. Counsel, you'll each have 20 minutes to present your argument. Mr. Mata, how much time would you like to reserve for your rebuttal?
I'd like to keep it at 20 minutes, but there are some issues that were a surprise in the evidentiary hearing that were in my favor. So I think it'll take 30 minutes.
Well, we have a 20-minute time limit unless the board has questions. And so you can reserve some of those minutes for rebuttal, but those will be deducted from your 20 minutes.
Thank you.
How many minutes would you like to reserve for rebuttal?
10.
Okay. That means you'll have 10 minutes to begin. We have a timer that you should be able to see in one of the Zoom boxes. Can you see that, Mr. Mata? There's a box that says Blue Sky Timer.
I don't see it. Share screen, more, leave. Don't want to do that.
It's
View.
among the boxes with everyone's pictures. There's one that says Blue Sky Timer. Has a blue background. That's where the timer will appear, but I will give you a 3-minute warning and then let you know when your time is through. Okay?
By the way, I don't know if it's relevant. I've never done this. In fact, I've never done the trial. I don't see the other participants on the board. Are they going to be there?
The board is all here and we are on the screen if you are in the gallery view. And Mr. Lang, representing the commission, is also present on the screen.
Okay, my daughter's going to go get me some speakers to see if that helps because I can barely hear you. But this is what I do for doctor visits, although I've never done Zoom, so those speakers will hopefully help.
Okay, we can hear you, and so you may begin, you may proceed with your argument.
Thank you. May it please the board. My name is Mario Mata. I'm an attorney that graduated from University of Texas in November 1978. I've practiced several areas of law, board certified in commercial real estate. When I got to when the bankruptcy code was amended, I didn't do any more bankruptcy code work. I did real estate work, but bluntly, I found that doing international and offshore trust work was far more beneficial. Now, I'm assuming, and you correct me if I'm wrong, that the members of the panel are not particularly well versed in offshore transactions, offshore trust, offshore companies, and why we do it. I think, would that be a fair assumption?
I'm not familiar with everyone's experience on the board, but go ahead and tell us whatever it is you think we need to know.
Well, it's an extremely complex matter because what we're doing is setting up a foreign trust in a foreign jurisdiction and having the assets of the trust be in Switzerland. The settlor beneficiary of the trust is typically the client. And during the process, I don't get involved in the funding of the trust because I don't have any authority to do that. I don't have, you know, the people holding the assets in the United States are not going to take my word or authority to transfer those funds. So those funds are all transferred by Mr. Moser. Now, you might ask, and I'm always asked this question, so I'll volunteer it. Why do you have to go offshore? The reason is,
if I could interrupt, I just want to remind you that the legal issue in your appeal is whether the grievance is barred by the statute of limitations. So you may want to direct your comments to that legal argument, given the limited time.
okay, well, as you may know, I filed a motion to add to the evidence that was going to be presented here, several exhibits, multiple exhibits, actually just 3 exhibits, because of the fact that the commission had added those, which made me realize that maybe I should have done that. That motion was denied for the simple reason that the board felt that those documents were already part of the record. And therefore, there was no reason to supplement what was already in the record, which was just fine with me. In fact, I like the language that the Board of Disciplinary, that's the wrong denial. They denied it in any event because they felt that was on the record. But the main thing that is critical here is I try to underscore to appellate counsel that both at the evidentiary hearing and in my brief, there was no evidence that this infamous January bank statement of 2014 existed. The board has relied on that significantly and has never changed its position. And the reason it's so important to this case is because if the complainant had received that statement and that was his first opportunity to notice that the funds that he was expecting had not been transferred, were not there. However, I hinted in my brief that the filings of the commission had all made reference to this January 2014 statement, which of course would have made the grievance timely filed. But there is no January 2014 statement. And I know that just from experience from dealing with this bank, Vontobel Bank and Swiss American Advisors. So they went back and in my supplement, I pointed out the fact that the statements come in on a daily basis, I'm sorry, on a quarterly basis, and Mr. Moser claims that he did not realize that the $275,000 that he was looking for was not there. And he didn't realize that until he got his January 214 statement. There is no 2014 monthly bank statement. I get a copy of everything from the bank that that Mr. Moser gets, and I apologize, but I didn't realize I was going to go first. I thought I was going to go last, but the supplemental the supplement to the record, which was accepted by MOTA, made it clear, absolutely clear, that a third and fourth quarter investment statement had been filed. And
Mr. Mata, I'm sorry to interrupt you, sir. This is Michael Gross. I'm just curious if I could ask you, you've only got 2 minutes left on the clock. Why did you not raise statute of limitations below, sir?
because I'm not a litigator. In fact, most of my law is practicing foreign law.
Okay, what's your position today on the statute of limitations, Mr. Mata?
The statute of limitations expired because when the complainant received his third quarter, that period ended in September of 2013. And then there was a statement for 2014, the fourth quarter. And there is this reference to an January bank statement. That's when he discovered that the funds were not there, but no, a statement was issued in the third quarter. And that's when he should have realized through due diligence that the funds were not there. There were other funds that were not there, tax funds, but they were not there. They were not there. And therefore, he should have realized when he got that third quarter statement that the funds were not there, and there was about $154,000 in tax money that was also not there. And the reason I didn't raise the statute of limitations because I'm not a litigator, sir, and I don't know the first thing about litigation. And I did not file an answer. And as you may or may not know, I cited court cases that specifically said that if an affirmative defense is not raised during the trial, then the defendant can raise those issues for the first time on appeal. Now, those are court cases, of course, but I have no reason to believe that they did not apply in this case.
Okay, Mr. Mata, your initial time is up, so we will let the commission have their 20 minutes, and then you'll have your rebuttal time.
Thank you.
Mr. Lang, you may proceed.
May it please the chair and the commission and the board. The point here, as Mr. Mata has finally addressed, is that he did not raise the statute of limitations, which he asserted in his brief. He did not raise it at all. He filed no answer. And during the course of the proceedings at the panel, there was no hint of any point raised by Mr. Mata about the statute of limitations. I would also respectfully point out that the cases that have been cited by the appellant say nothing about the defendant being able to raise an affirmative defense on appeal for the first time. Contrary to that, the cases clearly say if there is not an issue raised as to the statute of limitations as an affirmative defense at the time of trial, the issue is not preserved and cannot be brought forward. Furthermore, there is an allegation in the brief that the matter was tried by consent. As I'm sure the board knows, but let me say it for the record, trial by consent is only evident where both parties have addressed the issue in the trial and the court has been fully aware that that issue is before the court. Now, the Pine Trail case, which we cited in our brief, makes it very clear what it takes. If not properly pleaded, but the issue is brought before the trial court by the active assistance of both parties, will be considered to have been properly raised to the trial court. There is no citation to the record by the appellant that occurred. There is nothing in the record on that. Therefore, the issue is not preserved, and respectfully, it should not be before the board as an issue at all. Under the substantial evidence rule, which is the standard for review in this matter, there is ample evidence, much more than a scintilla, that the appellant received $270,000 from Mr. Mosier, from Dr. Mosier. It was put into the appellant's IOLTA account with directions that it would be transferred to the Swiss bank, Vontabell, for the purpose of being part of the Cook Island Trust that Dr. Mosier had started. That money was put into the IOLTA account, but then over a period of time, it was put into the appellant's pocket. He violated his sacred trust as a lawyer, not only as counsel, his fiduciary duty, but also under Rule 1.14B to hold that money in trust. And he did not do so. He has never accounted for what he did with that money. He said nothing until Dr. Moser's lawyer, which is all in the record, made demand for the return of that money. He has not returned it to this day, nor has he accounted. So we respectfully request that on this record, the sanction of disbarment be upheld.
Mr. Lang, if I could interrupt, if the grievance that or the misconduct that was found against Mr. Mata was failure to return funds, when does a failure to return or a failure to act occur?
Well, it's ongoing at this very day. I mean, the demands were made in 2014 by counsel for Dr. Moser. The letters from counsel and the testimony of Dr. Moser's counsel is there. It's crystal clear. There were apparently, according to Dr. Moser's counsel, there were representations by the appellant that I'll give it back. I'll give it back. It's never been done to this day. There is no accounting that has been provided as required by the disciplinary rules. So even were the board to look at the issue of statute of limitations, it's an ongoing ongoing violation. But furthermore, the board, the panel determines the credibility of the witnesses and the weight to give to the evidence. That's their providence. And they determined that when Dr. Moser said, I did not learn about this until I received the third quarter 2013 statement, and I saw that there was nothing that was deposited. Mr. Mata must have done something wrong, or he must have just not taken care of business. But mid-January 2014, when Dr. Moser said he received it, is certainly a period that is 4 years from there. He filed his grievance on January 2, 2018. So we are within the 4 years, even were one to assume that there was statute of limitations raised. The facts are there on the record, but in the alternative, of course, as I said, we have a situation where this is an ongoing violation. He has not returned the money. We have seen in the record that he used it and put it in his own pocket. The only issue raised was statute of limitations. And again, respectfully to the board, I say he did not raise it. The rules of civil procedure are incorporated into the Texas Rules of Disciplinary Procedure to the extent that they are not inconsistent with the procedural rules. And Rule 93 requires an affirmative defense to be raised, and it's raised by pleadings according to the case law. It was not there. And furthermore, as I pointed out early in this argument, it was not tried by consent, which was one of the issues raised by the appellant. There is no hint in the record of any suggestion that there is a statute of limitations problem.
Mr. Lang, this is Michael Gross. I'm sorry to interrupt. I had a question for you if I could, sir.
Yes, sir.
So do you agree that Mr. Moser, you know, he saw the third quarter bank statement back in October 2013. Don't you think he should have discovered any possible misconduct by Mr. Mata at that time back in October 2013?
I don't think he's put on notice of that, Mr. Gross, and here's why. The SV case from the Supreme Court that we've cited makes it very clear when there is a fiduciary duty, the party that is wronged, to whom the fiduciary duty is to be accorded, is not under a strict scrutiny obligation. But once it does come to that person's attention that there's a problem, then he must raise it. Now, the third quarter statement showed, as the board will be aware by looking at the record, does not show a deposit. That third quarter statement goes through the end of September. The money was provided to Mr. Mata within the month prior to that. And it should not ring bells necessarily if one looks at that statement and says, well, it didn't show up here. Well, it must be coming. But certainly the year-end statement for that final quarter that shows a zero balance in that account, and it demonstrates the money was not transferred, that rang the bell. And that's when Dr. Moser proceeded to try to find out what is going on. And he got no answers for quite some time, never was told about where the money went, but we found out in the record it went into the appellant's pocket.
Mr. Lang, you said that on the trial by consent issue, that there's no indication in the record of the limitations issue, but on page 19 of the transcript in Ms. DeBerry's opening statement for the commission, doesn't she address the limitations issue at some length?
Well, I don't think it was ever addressed by being joined during the trial. The appellant didn't raise it. He didn't say anything about it. And there was no discussion during the trial of statute of limitations. And that is a classic requirement in any trial, that the party utter the words statute of limitations or talk about time barred or something to give the panel some idea of what was going on. But nevertheless, even were the board to consider this issue, the fact is that it wasn't raised, and credibility is judged by the panel at this point, and they give weight to the evidence that they believe is appropriate. It's their discretion. Now, when Dr. Moser said, I learned about this when I got that statement in mid-January 2014, they gave credit to that, and they made that determination. And there was no contest at that time in the evidence by the appellant about any issue with that testimony. So therefore, on the record, Madam Chair, on the record, we don't have the issue of statute of limitations raised. It's not tried by consent, and even assuming that the board looks at the statute of limitations, it's the panel that made the determination about the credibility of the testimony and the weight to give to it, and they did so. And they found that there was a violation, and they have judged in their discretion what the appropriate sanction was, which is disbarment.
Thank you, Mr. Lang. Do any other board members have questions for the commission?
I do. Mr. Lang, it's good to see you. Thanks for your clear brief and your clear argument. I want to bounce an idea off of you very quickly. I don't want to take up too much of our time here today with this, but I think it's pretty important, and I suspect it's right, but I want to hear your take on it. It has to do with limitations in jurisdiction. Usually limitations is a pleading requirement. The plaintiff has to plead certain causes of action by a certain time pursuant to Chapter 16 of the Civil Practice and Remedies Code. And the defendant has to plead limitations as an affirmative defense under Civil Procedure 94. But the limitations rule that governs this case, Texas Rule of Disciplinary Procedure 17.06, is not a pleading requirement like Chapter 16 of the Civil Practice and Remedies Code. It is something very different, I think. It seems like it's a time restriction on the power of the bar to discipline an attorney. The accused attorney cannot, by waiver or some other means, convert a restriction on the bar's power into an expansion of the bar's power. I think only the Supreme Court can do that, and then only through a rule change. So it seems to me that limitations here is not something the accused attorney can waive. It's about the power of an adjudicator to resolve a case. It seems jurisdictional to me, again, because of the different basis for limitations. Chapter 16, in the case of most cases, Rule 17.06 here. Again, 17.06 is a restriction on the bar's power to discipline an attorney rather than a pleading requirement that's placed on plaintiff in the first instance and a defendant as an affirmative defense. What do you think about that?
Well, thank you for the question, Mr. Boatwright. There is jurisdiction on this record were we to look at it on that basis, because the time when Dr. Moser said that he first learned about the issue was mid-January 2014. That's the only testimony in the record about when that came to his attention. The grievance was filed January 2, 2018, within the 4 years. So on this record, on the facts, there is no jurisdictional issue.
Any other questions for the commission?
I'd like a point, 2 points, just to only take 1 minute.
Mr. Mata, let me just make sure no one has any other questions for the commission.
Thank you.
Nope. Mr. Lang, would you like to add anything else?
No, ma'am, I appreciate very much the opportunity to present, and I will await the response of the appellant.
Thank you. Thank you for your briefing and argument. Ms. Truitt, if we could reset the clock for 10 minutes. Mr. Mata, you have 10 minutes in rebuttal.
One of the principal mistakes and something that was shot down at the evidentiary committee or panel was I tried to bring up the fact that this was not Dr. Moser's funds. The panel didn't want to hear about it. They didn't want to hear about it. They said it's his money. Much to my shock, when the judgment of disbarment was issued, it was made payable to his mother's trust, which is the Moser Family Trust, which has got one principal beneficiary and about 8 contingent beneficiaries. My job, although I didn't know it at the time, is that he expected a challenge to his withdrawal of the funds from that trust. And he wanted to make sure that he put it in a form where it could be protected from the family. But the fact of the matter is that I realized that issue also when, as far as proper party, and he should have brought it as trustee when I thought of that issue, but I decided not to bring it. And yet, despite the fact that the evidentiary panel didn't want to hear it, they got it right. They decided that it did belong to Mrs. Moser's trust. Secondly, I filed a motion which was granted to supplement the record because the order in which these statements from the third and fourth quarter from Von Tobel Bank just simply did not make sense. As a matter of fact, the cover sheet starts out November 30th, 2013, and then it starts talking about December 31st, created on January 1, which would clearly make the filing on a timely basis. Then you look at the back of the commission's own documents, they have another quarter named September 30th, 2013, in which they finally put in the 2013, I'm sorry, the third quarter statements, but they're out of order. And I immediately noticed that the purpose of my supplemental record is to place these documents in the correct chronological and numeric order that they were issued by Von Tobel Bank for the quarter ending September 30th. And it's very, I mean, it's in the record, except that mine, it just says it's a cover sheet September 30th, 2013. It starts out with the activity of December 31st. By that time, it's problematic, especially, and I think I implied in my brief, where is this January 2014 bank statement? The commission has never produced it, and I know why they haven't produced it, because it doesn't exist. It doesn't exist.
The evidence, as I understand it, or the argument is that he received the fourth quarter statement in mid-January, that there's not a January statement.
Yes, but if he received the third quarter statement, that would have been for the period ending September 30th. And that he was close, but he would have missed the statute of limitations limitations by that time, because I think in the commission's petition, they conceded the point that it takes about 10 days to get those things mailed. So he would have had it on around October 10, by which time it was already too late for the filing of a grievance. And I frankly did not, especially since I'm not a litigator, did not bring up the fact that he filed it in the wrong capacity. He filed it in an individual capacity, and if you look at his grievance, so he could go into his personal trust, but the evidentiary panel found that that money belonged to his mother's trust, and he should have not been taking it out of that trust. That trust has now been depleted. And I strongly encourage the party and the panel to look at the documents that the panel, or I'm sorry, well, yes, the panel allowed me to supplement the record with. I lost you.
I'm muted, sorry. I said that we will review the record. Do any board members have any questions for Mr. Mata?
Mr. Mata, this is David Iglesias. You had mentioned, or at least as I understood it, you had mentioned in your previous argument that you have reviewed cases that stand for the proposition that the statute of limitations can be raised for the first time on appeal. First of all, did I understand that correctly? And second of all, if so, what is the best case for that proposition that the statute of limitations can be raised for the first time on appeal in a case like this?
I based my conclusions based on the the Texas Supreme Court of Texas decision in Rourke versus Stallworth Oil that I do recite in my brief. And I went right for the heart of it. And basically it said, if you don't raise the issue and the petitioner does nothing about it, then they have waived the right to prevent the respondent from bringing it up at appeal. And this is particularly important because it could have easily, with one sentence and the judgment, been resolved. As you typically see, I'm not a litigator, but I've seen enough judgments to say all of the relief not granted herein is hereby denied. Well, it could have said, and the state bar may actually want to think about this, it could have all say all relief, including affirmative defenses, are hereby denied, but they didn't do that. And that's why the Rourke case makes it very clear, and that's a Texas Supreme Court case, that if a respondent does not bring up the affirmative defense and the petitioner doesn't do anything about it, then the respondent has an opportunity to bring it up for the very first time on appeal.
Thank you, Mr. Mata. Thank you for your argument. If you don't have anything further, then the board will take this matter under advisement.
Thank you.
Thank you. You are excused.
Thank you.
Thank you very much.